A federal judge just took a legal sledgehammer to the Justice Department's leadership. In a blistering 100-page ruling, that same judge accused the highest levels of the DOJ of orchestrating a power grab so brazen, so defiant of the law, that it threatens to invalidate thousands of federal cases. This isn't some dusty legal technicality. It's a full-blown constitutional crisis unfolding in real time. And at the very center of the storm is one of the most powerful prosecutors' offices in the country, the U.S. Attorney's Office for the District of Columbia. A federal judge has officially branded a 3-person team running the D.C. U.S. Attorney's Office an unlawful triumvirate, exposing a high-stakes power play that goes straight to the top. But this isn't just about D.C., it's a pattern. At least 6 similar appointments in states like New Jersey, California, and Nevada have already been struck down by the courts. This single ruling calls into question the legitimacy of thousands of federal prosecutions and accuses the Attorney General of inventing a scheme so unprecedented it had to be given a whole new name. I've dug through the court records and the legal history behind this showdown, and the official statements don't tell you half the story. What's really going on is a constitutional standoff between the executive branch and the federal judiciary. Stick with me, because you need to understand what the judge found, why it's so explosive, and why the administration seems to be daring the courts to do something about it. To get why the D.C. U.S. Attorney's Office is in total chaos, you first have to understand the law for how these powerful jobs are supposed to be filled, and for that, we need to talk about the Constitution. The Appointments Clause in Article 2 is the bedrock of this whole fight. It's the official rulebook for appointing officers of the United States. For the big jobs, like cabinet secretaries, the president nominates them, and the Senate confirms. Simple. But the clause also lets Congress create a different track for what it calls inferior officers. Congress can write a law that lets the president alone, heads of departments, or even the courts appoint these officials. This is key because a U.S. attorney, one of 93 top federal prosecutors, is one of these powerful officers. And for over a century, Congress has had very specific laws to handle vacancies in these jobs, precisely to stop the kind of mess we're seeing now. The main law today is the Federal Vacancies Reform Act, or FVRA. It's the modern playbook. When a U.S. attorney job opens up, the FVRA says the Attorney General can appoint an interim U.S. attorney for 120 days. That's a 4-month window for the president to find a permanent replacement and for the Senate to vet them. But what if that 120-day clock runs out? Well, Congress had a backup plan. A different law, 28 U.S. Code Section 546, is the safety valve. It says that if the job is still empty after the interim period, the local federal district court may appoint a U.S. attorney until the position is filled properly. This is a critical check and balance. It stops a prosecutor's office from being stuck in leadership limbo and prevents the White House from just installing temporary loyalists forever, completely bypassing the Senate. Now, rewind to early 2025. After the inauguration, the D.C. U.S. Attorney, Matthew Graves, resigned, which is standard when a new administration comes in. This opened up a job in arguably the most sensitive prosecutor's office in the country, which handles everything from local D.C. crimes to January 6th cases. The new administration moved fast, but instead of nominating a seasoned prosecutor for the Senate to review, it used the FVRA to make a temporary interim appointment. Their pick? Ed Martin, a political loyalist known for championing the Stop the Steal movement and even representing January 6th defendants. The choice was a political firestorm from day one. Senate Democrats called Martin dangerously unqualified. In an unprecedented move, nearly 100 former D.C. prosecutors from both Republican and Democratic administrations signed a memo begging the Senate to reject him. They wrote, "There is a time when we all are called to stand for the full and fair administration of justice and the rule of law. For those of us who have served in the office of the United States Attorney and still have a breath, that time is now." The administration sent Martin's name for permanent confirmation, but with that much opposition, the nomination was dead on arrival. And so the clock started ticking on his 120-day interim term. According to the law, once that deadline passed, the power to appoint a replacement would flip to the federal judges in D.C. But the Justice Department had other plans. They decided to play a game of musical chairs with job titles, arguing they had some other inherent authority to keep their guy in place. They were already trying this move in other states like New Jersey, California, and Virginia, and it was failing spectacularly. In case after case, federal judges were striking these appointments down. One federal appeals court looked at a similar situation in New Jersey and flatly called the DOJ's maneuver plainly prohibited. Back in D.C., a legal challenge was filed. Defense attorneys argued that Ed Martin's 120 days were up, and he no longer had the legal authority to prosecute their client. The Justice Department fired back, claiming broad executive power. The case landed before a D.C. federal judge, and the ruling was a bombshell. The judge found that the Vacancies Act was the only legal way to fill the job. The administration's attempt to get around the 120-day limit was illegal. Ed Martin was declared to be serving unlawfully. He had zero authority to lead the office. The first domino had fallen. The administration's hand-picked prosecutor for the most important district in America was just disqualified by a court. That should have been it. The law was crystal clear. The D.C. judges now had the ball. But what the Justice Department did next was something nobody saw coming. It was a move so audacious, a federal judge would later call it a constitutional abomination. The ruling that disqualified Ed Martin should have been a moment of clarity. The administration tried an end run around the Senate, and a judge stopped them. The law said the next move belonged to the D.C. District Court. The judges would appoint a veteran prosecutor to run the office until a permanent Senate-confirmed U.S. attorney was in place. That's the system Congress designed. Instead, the Attorney General chose defiance. The day after Martin was disqualified, the Attorney General issued a bizarre internal order. It didn't name a new interim U.S. attorney. Instead, it carved up the job itself. The authority of the office was split among 3 separate people in a structure never before seen in American history. Let's call them the triumvirate. The order put one person in charge of all criminal cases, a second in charge of all civil cases, and a third in charge of all administrative duties. Together, this committee would run the office, but not a single one of them would actually hold the title of U.S. Attorney. It was a transparent scheme. The logic seemed to be, if the court says we can't have one illegal U.S. attorney, fine. We'll have 3 officials who aren't called the U.S. attorney, but who do the entire job. It was a word game, a legal fiction designed to argue that they hadn't technically violated the court order because no single person had the top title. They were claiming the power to just delegate the duties of a Senate-confirmed officer to a committee of subordinates, forever. And this wasn't some new idea. It was a recycled version of a strategy that had just failed in other courts. In New Jersey, after Trump ally Alina Habba was disqualified from serving as U.S. attorney, Attorney General Pam Bondi tried the exact same triumvirate ploy with 3 loyalists, Philip Lamparello, Jordan Fox, and Ari Fontecchio. A federal judge there, Matthew Brann, shut it down in a scathing opinion, calling it an illegal power grab. Judge Brann wrote that the administration seemed to believe it had discovered enormous grants of executive power hidden in the vagaries and silences of the code. The DOJ and D.C. knew this. They'd seen the New Jersey ruling. And they did it anyway. It was a direct challenge to the judiciary, escalating a legal dispute into a full-blown confrontation over the separation of powers. The move sent shockwaves through the D.C. legal community. Inside the U.S. Attorney's Office, prosecutors were baffled. Who was actually in charge? Who had the final say on a plea deal or a sensitive indictment? The chain of command, the backbone of any prosecutor's office, had been intentionally shattered. Publicly, the administration acted like nothing was wrong. The Deputy Attorney General posted a defiant message on social media that basically said, "Judges don't pick prosecutors. The President does." See Article 2. It was a stunning misreading of the Constitution, one that conveniently ignored the part of Article 2 that gives Congress the power to let the courts appoint officers, exactly what the law does for U.S. attorney vacancies. This wasn't just a bureaucratic shuffle. It was a radical claim of executive power. The DOJ was arguing it could ignore a federal law and a direct court order. If this was allowed to stand, it would create a blueprint for dismantling the independence of any office in the government. It was only a matter of time before this bizarre new triumvirate would have its own day in court, and that legal showdown would expose it for exactly what it was: a constitutional absurdity. The DC triumvirate was a constitutional tripwire, and it got tripped almost immediately. Just like before, defense attorneys in a federal felony case filed a motion to dismiss the indictment. Their argument was simple and devastating. The charge against our client is invalid because the office that brought it is being run by an illegal, unconstitutional committee. Forced to defend its three-headed creation, the Justice Department marched into court with a truly breathtaking argument. Their lawyers claimed the Attorney General has a nearly absolute, inherent power to delegate prosecutorial authority to anyone in the department. As long as no one was officially called acting U.S. Attorney, they argued, they were free to slice and dice the duties of the office however they wanted. They were essentially arguing that the job title was a magic word. Call it a leadership committee, and the rules of the Constitution just disappear. This was a radical theory. It meant the executive branch could bypass the Senate for any inferior officer by just breaking the job into pieces and handing them to political loyalists. It was an argument for unchecked power, treating the constitutional appointments process like an annoying suggestion you could creatively rebrand your way around. The challengers, backed by a coalition of defense lawyers and former DOJ officials, fired back with the plain text of the Constitution and federal law. They called the triumvirate a rhetorical smokescreen, a sham designed to do exactly what the last court order prohibited: keep the office under the control of unconfirmed political appointees. They pointed out that the authority of a U.S. attorney is singular and consolidated. You can't just chop it up and hand it out like party favors. The law, they argued, requires a single accountable officer in charge. This three-person committee answered to no one but the Attorney General, who invented their jobs out of thin air. It was a flagrant violation of the Appointments Clause, because these three individuals were effectively acting as a U.S. attorney in all but name. The case landed before a senior federal judge in Washington, D.C., known for a meticulous, nonpartisan approach. The legal world held its breath. When the decision finally came, it was a legal bombshell. In a massive 130-page opinion, the judge didn't just rule against the government. The judge dismantled the DOJ's entire argument, piece by painful piece. The judge called the triumvirate a constitutional fiction and a structure without precedent in American history. The court found the DOJ's whole argument about delegation was a red herring. The power to delegate administrative tasks, the judge wrote, does not include the power to deconstruct a statutory office created by Congress and reconstitute it in a manner that eviscerates the appointments process. The opinion methodically laid out the history of the Appointments Clause and the Vacancies Act. The judge found that Congress had created a clear and exclusive system for filling these jobs. The DOJ's claim that it could just invent its own leadership structures was, in the judge's words, an assertion of executive power that finds no home in our constitutional tradition. One of the most powerful parts of the ruling targeted the DOJ's word games. Paraphrasing the sentiment from similar real-world rulings, the judge wrote, "This court is not fooled by the government's rhetorical smokescreen. Whether it's one person serving unlawfully or three people sharing the unlawful authority, the constitutional violation is the same. The U.S. Attorney's Office is being run by officers who have not been appointed according to the Constitution." The judge explicitly pointed to the administration's failed attempts in other districts, noting the DOJ had been repeatedly warned by federal courts across the country that its legal theories were junk. The decision to try the same failed strategy again in D.C. was described as a willful disregard for judicial authority and the rule of law. In a stunning climax, the judge declared the triumvirate structure itself unlawful and ordered all three members disqualified from exercising any prosecutorial power. And the judge didn't mince words about the consequences, warning that every single action taken by this triumvirate, every indictment, every plea deal, every legal filing, was now under a cloud of constitutional illegitimacy. The ruling ended with a grim warning. If the administration continued its unlawful attempts to fill the office, the court would have to consider the ultimate sanction: dismissing criminal cases. The judge pointed out the dark irony. An administration claiming to be about law and order was, through its own illegal actions, about to jeopardize scores of prosecutions against dangerous criminals. This is the heart of the crisis. A federal court has exposed a systematic attempt to bypass the Constitution. This isn't about politics. It's about the fundamental rules of our republic. If you believe the rule of law is worth defending and that no one is above it, then hit that subscribe button and turn on notifications. Because what happens next in this fight could define the limits of executive power for a generation. The judge's ruling wasn't just a slap on the wrist, it was a legal earthquake. The consequences are sprawling, complex, and frankly, alarming. First, and most immediate, is the fate of the cases. The D.C. U.S. Attorney's Office handles thousands of criminal prosecutions. For months, it was run by a leadership team a federal judge has now declared unconstitutional. That means every major decision made during that time is now potentially invalid. Think about that. Every indictment signed, every plea bargain approved, every search warrant requested, all of it was done under the authority of officials who, the court says, had no legal right to be in their jobs. This has created a legal nightmare. Defense attorneys all over D.C. are preparing a tsunami of motions to get cases thrown out. Their logic is simple. If the authority that brought the charge was illegitimate, the charge itself is void. As Judge Brann warned in the similar New Jersey case, this could lead to the dismissal of cases against scores of dangerous criminals. The government will almost certainly fall back on a legal principle called the de facto officer doctrine. It's a kind of safety net that says the actions of a person who holds an office in good faith are still valid, even if their appointment later turns out to be flawed. The idea is to stop the entire government from grinding to a halt over procedural mistakes. But here's the problem. It's not at all clear that doctrine would save them here. It's designed for good faith mistakes. The judge's ruling basically called the triumvirate a bad faith scheme, a willful attempt to defy the law and prior court orders. A judge could easily decide you don't get to benefit from a good faith doctrine when you were acting in blatant bad faith. If courts refuse to apply it, we could see a catastrophic collapse of cases. Everything from complex financial fraud to violent crime prosecutions could be tossed out on a constitutional technicality created by the Justice Department itself. Beyond the courtroom chaos, this is a profound breakdown in the separation of powers. This is the executive branch being told its actions are illegal, responding by doing the exact same thing again, and then getting told again that it's illegal. When judges in Virginia and New York used their legal authority to appoint their own interim U.S. attorneys, the DOJ's response was to fire them. Deputy Attorney General Todd Blanche even went on X, formerly Twitter, to announce the firings, declaring, "You are fired," and stating that judges don't pick prosecutors. This isn't a legal dispute anymore. It's a bare-knuckled political brawl. As one retired federal judge, Robert Kugler, put it, "It's crazy. It doesn't make any sense." The judiciary is using its only real tool, legal rulings, to act as a constitutional guardrail. But if the executive branch just ignores those rulings or fires the officials the courts lawfully appoint, we enter a dangerous new phase. It becomes a raw test of wills, what scholars call a constitutional standoff. And that kind of open conflict erodes public trust in the entire justice system. In a related case in New Jersey, a frustrated Judge Zahid Qureshi hauled the illegal leadership trio into his courtroom, telling them they have lost the confidence and the trust of the courts and the public. That loss of trust is the poison that can paralyze the law itself. The judge's ruling against the D.C. triumvirate, as decisive as it was, isn't the end of the story. It's just the end of a chapter. We are now heading for a long and ugly constitutional battle. The immediate next step is an appeal. The DOJ will fight this. They'll take it to the D.C. Circuit Court of Appeals, and from there it will almost certainly go to the Supreme Court. That means the ultimate question of whether an administration can simply ignore the Senate and the courts to install its own prosecutors will likely be decided by the 9 justices. For now, the judge has paused the order disqualifying the triumvirate, mainly to prevent the U.S. Attorney's Office from imploding overnight. But this came with a grave warning. The judge stated that the administration proceeds at its own risk, and that the pause cannot validate an unlawful appointment. This puts the DOJ in a terrible spot. Everything the triumvirate does while the appeal is pending is still constitutionally tainted. They're operating on borrowed time, under a judicial thundercloud that threatens to wash away everything they do. The judge also drew a very clear line in the sand. The ruling contained a stark warning for the future. Any further attempts to unlawfully fill the office will trigger the immediate dismissal of cases. This is not a bluff. This is a federal judge telling the executive branch that the games are over. This sets up a high-stakes game of chicken. Will the administration finally back down, or will they try another clever scheme to maintain control? Based on their pattern, firing court-appointed prosecutors, ignoring judicial smackdowns, and recycling failed legal arguments, there's every reason to believe they'll keep pushing. This is more than a fight over a few jobs. It's a struggle over the character of American government. It's a test of whether the constitutional checks and balances designed to prevent the concentration of power still mean anything. The judiciary has built a firewall. The executive branch is trying to tear it down. What hangs in the balance isn't just the fate of thousands of criminal cases, but the very principle that this is a government of laws, not of men. This is an ongoing crisis, and we'll be watching every move.